Good afternoon and welcome to Greenfields Solicitors channel. Greenfields Solicitors are a firm of specialist immigration, human rights and nationality solicitors based in London. My name is Raheela Hussain and I am the Principal Solicitor of Greenfields Solicitors. Today is Wednesday, 17th of June 2015, and this afternoon's show is to provide our viewers with helpful information on immigration and human rights law. And today's topic is overstayers, which is always a very popular topic at Greenfields Solicitors. Now, this afternoon I'd like to discuss the type of applications overstayers can make to the Home Office to try and regularise their lawful status in the UK. Overstayers are people who are defined as those who have entered the UK on a visa, but for whatever reason have remained in the UK beyond the validity of their visa. So effectively they have overstayed their visa in the UK. There are all types of visas which can be overstayed once a person comes into the UK, including visit visas or Tier 4 student visas, settlement visas where a marriage has broken down and a person says, you know what, I still wish to remain in the UK, I can't return back to my home country. Now, a discretionary leave to remain legal status is the name of the legal category which is given to people who are successful when making an application for regularisation of legal status. So where a person makes an application to the Home Office and says, look, I'm an overstayer, can I get lawful status in the UK? Then the Home Office, if they successfully deem that application to have merit, then they will grant that person an initial grant of 2.5 years for legal status in the UK. After then, you can extend that visa for a further period of up to 10 years, and at the end of that period you can then apply for indefinite leave to remain and then eventually make an application for British nationality. So the type of clients and inquiries that we have on a day-to-day basis vary. We have clients from all over the country and all over the world. Indeed, we have clients coming from Nigeria, Zimbabwe, Uganda, Mexico, India, Pakistan, all over the world, and they ask us whether they can make an application to remain in the UK lawfully if they have overstayed their visa. Now, there is something called paragraph 276 AD of the immigration rules, and one of the subsections within those rules is where the Home Office assesses an application based on whether that person has strong ties in the UK and whether there are very significant insurmountable obstacles or whether that person can return back to their native home country. So where a person has established a private and family life in the UK, so they have maybe family members here or children being a very strong bond to the UK, or a partner or friends or some sort of reason why it's in their interest to remain here, and indeed in the interest of British society to have a person like that to remain here, then they can make an application for regularisation of lawful status. Now, what's interesting is the Home Office will look into what ties that person has back in their home country. So, for example, if they do have family back home or if they do have property they own back home, the Home Office will say, well, you know, it's not too difficult for you to reintegrate, even if you have been in the UK for a number of years. So therefore, it's really very important where a person is thinking of making such an application for discretionary leave to remain, they try and get the best legal advice and accurate legal advice possible, as it's really important that they try and submit the best case to the Home Office in the first instance, which will therefore grant them the best opportunity to obtain lawful status in the first instance. So at Greenfields Solicitors, we have clients who approach us, and I can give some case scenarios where the firm has successfully helped clients obtain lawful status. Speaking about a particular client from Africa, one of the African countries who approached this firm, he had been here for over 11 years and he was here unlawfully, having overstayed a visit visa. Now, as are many overstayers, they are quite scared of the system and being caught, so they tend to remain under the radar as such. What this means is this particular client had no documents really in his name, or very few I should say, over the years that showed that he was actually resident in the UK for the period he claimed. But what was interesting was that he actually had a partner of a different ethnicity. She was of English ethnicity, and they had a child who was therefore mixed race. The child automatically adopted British nationality through his mother, as the law does allow a child to obtain British citizenship if the parent has settled status. And Greenfields Solicitors assisted this gentleman in submitting an application to the Home Office and arguing his human rights which is the right to private and family life, relying on Article 8 of the Human Rights Act 1998, along with paragraph 276 AD, in that this firm argued that he had stronger ties in the UK than back in his home country, along with obviously the children's laws. So what's in the best interest of his child, who's a British child, in that the child should have the right to have both of his parents in the UK and be afforded the right to live a British lifestyle as a child was a British citizen. Now, there was a lot of documentation that we submitted with this particular application to show that the family relationship our client had was genuine and he was very much part of his child's life. And when we submitted this application, it was only a matter of weeks before the Secretary of State indeed wrote to us conferring that the client had been granted discretionary leave to remain for a 2.5-year basis. Obviously the client was very happy, as was his partner, and that's just one of the situations where we at Greenfields Solicitors have helped overstayers regulise their status. Now, we also have people who have no children and wish to remain here, so single people, they wish to make an application to remain in the UK because they say they may not have any family to return to. Some parents have passed away in their home countries, their siblings are married or they have no siblings, and therefore they have no assets or ties or anything to welcome them back home if they return to their home country in, say, Ghana, Zimbabwe, India. And in the meantime they have established a life in the UK, a career, they've achieved some level of education, and they say, you know what, Mrs. Hussain, I would like to make an application to try and stay here. I feel I've really benefited the UK economy by paying taxes, and I certainly want to make an application to try and show that I would be somebody of calibre that the British economy would really benefit from having in the UK. So we also assist clients in those instances, and we have had situations where clients have successfully obtained discretionary leave to remain as on the basis of their private life under Article 8 of the Human Rights Act. Now, we also have clients who are involved in marriages and they are in the UK on spouse visas, but unfortunately the marriage has broken down. During the course of the spouse feature, which is also given for 2.5 years initially, if there are children of the marriage, then we can make an application requesting a variation of legal status, so that person should be granted discretionary leave to remain on the basis that the marriage has broken down. With or without children, it makes no difference, so long as a good case can be presented at the Home Office based on the individual circumstances. And we recently had a gentleman from the Indian subcontinent, and we successfully represented him in making an application and where he obtained a variation of legal status for discretionary leave to remain, and that was based on his marriage breakdown. So there are other circumstances when one can also request discretionary leave to remain. It's not just when one is an overstayer, but also when their visa is coming to an end, or when the visa that they have is no longer a valid visa and they should not remain on that particular route. For example, we had another lady from Nepal, and she was very close to her family members in the UK whom all were settled, they had indefinite or British nationality, and she had nothing to return back to in Nepal. Now, Greenfields Solicitors assisted this young lady in making an application requesting that before her then Tier 4 student visa expired, she should be granted discretionary leave to remain. We advised her in some detail on the type of documents that would assist her application, and indeed she too was granted discretionary leave to remain by the Secretary of State for a 2.5-year period. So essentially what we can kind of summarise is that where a person feels, well, what's my route, how can I stay here, I'm not sure if I fit into any particular immigration category, then they should always consider whether they can make discretionary leave to remain applications based on maybe their private life, their family life, the fact that they have no family or ties or assets to return to, and that there are very significant insurmountable obstacles preventing their return to their home country, or indeed if they have children and there are children's rights. Now, what's particularly interesting is under UK immigration law, where a migrant has established a family life or they have children in the UK, the government here take that very, very seriously. And we've seen quite a pattern at Greenfields Solicitors where one has a child, whether or not they are involved in that child's life in the sense that they have an ongoing family unit on a day-to-day basis, or where one has obtained a contact order, or they are amicable with their ex-partner and they can see that child and maintain a relationship with that child without the need of having any formal documentation in place, then the Home Office, the Secretary of State are quite open to considering whether a migrant in such circumstances should be granted leave to remain on a discretionary leave to remain basis. And this would be based because it would be in the best interests of that British child or the child who has legal status in the UK for their both of their parents to be remaining in the UK. So we do see quite a high success rate in such applications. So another example is where we had a client who was from Jamaica, and he had a long distance relationship with a lady who was based in the UK of a different ethnicity, and they had maintained their long distance relationship for a very long period, travelling to and fro. And on a more recent occasion, the gentleman decided on his trip to the UK as a visitor he wanted to try and make an application to remain here, so vary his lawful status and request discretionary leave to remain on the basis that he and his partner have a long-standing relationship, and on the basis that they did not actually want to get married. They do not want to be married according to their own ideology. So they said, you know, as an unmarried couple, as a couple that are happy to cohabit, and we have a very genuine, strong relationship, can I make an application to remain here? Certainly Greenfields Solicitors did represent this Jamaican gentleman, and again we provided quite a lot of information to the Home Office. Again, we tried to argue why there were significant insurmountable obstacles for his partner who's based in the UK to relocate to Jamaica. So for argument's sake, there were problems in the economy for her to get a job, and she had children here who relied on her, and we presented a case with documentation, and again the Secretary of State did grant the gentleman 2.5 years discretionary leave to remain. So I can give you lots and lots of different scenarios on when discretionary leave to remain has been granted to clients. We've been now operational approaching 8 years at Greenfields Solicitors, and our focus is only on immigration, human rights and nationality law, and therefore the team here only deals with queries, and we have a lot of queries from people asking us general questions, not just on overstayers but on appeals and spouse visas, on entry clearance applications, general Tier 4 general student administrative reviews, a whole range of legal immigration applications. And of course at Greenfields Solicitors we're very happy to help members of the public and offer them a consultation so they can initially obtain accurate advice that they can then rely on, think about, and whether they wish to proceed with any particular immigration application to try and get lawful status or extend their lawful leave in the UK. So often we have people both from inside the UK and outside the UK requesting legal advice, and we do offer a telephone consultation service at Greenfields Solicitors whereby you can have a consultation with myself, Raheela, Hussain, the Principal Solicitor, and I can provide you with advice over the telephone, in-depth, accurate advice going into your specific circumstances to try and assist you with your immigration matter. So this was just an overview today on overstayers, and I hope you have found it helpful. And if you would like to discuss your case with me or any of our staff at Greenfields Solicitors, then please do give us a call on 0208 884 1166, or do contact us at www.greenfieldsolicitors.com. In addition, you may wish to read some of my legal guides, which are published at Foreigners in UK, an online portal which is www.foreigners.in.uk.co.uk, and you will find a whole medley of guides written by myself on various immigration topics which try and help provide helpful information to people applying for visas or learning more about the UK immigration process. And I thank you for watching this afternoon's show with myself, Raheela Hussain of Greenfields Solicitors. I look forward to updating you again soon on immigration, human rights and nationality law. Thank you for watching.